You may know that the United States Supreme Court has taken up a big Second Amendment case this term. It's the most important and significant gun rights case in over a decade. And you better believe that the anti-gun crowd has been preparing for this fight for a long time with a lot of money. So what are they going to try to say to sabotage our right to keep and own firearms and to keep and carry firearms in public? Well, we're going to break it down for you when we come back. Hey folks, I'm Mark and welcome to the Four Boxes Diner. Today we're going to talk about the Supreme Court case of NYSERPA versus Bruen, or New York State Rifle and Pistol Association versus Bruen. The question in Bruen is whether states like the state of New York can put limits on your right to carry a handgun outside of your home. And why is this issue so important for your rights? It's because when the Second Amendment states that you have a right to keep and bear arms, it refers to two distinct but related concepts. You see, to keep means you have a right to own a gun, okay? And to bear means that you have a right to carry it outside in public. And in the Bruen case, New York and other states supporting New York are trying to basically gut your rights to bear arms or to carry guns outside. Now, the respected attorney and Second Amendment scholar named Stephen Halbrook, very famous guy in the Second Amendment community, he sums up the stakes of this case quite clearly. Quote, he says, quote, "If states can limit the right to carry, then it is not really a right, but rather a privilege subject to government controls and rationing." So how is New York actually going to argue this case before the Supreme Court? What are they going to say to try to ration or limit your constitutional rights under the Second Amendment? Well, I think what they're going to do is they're going to do a lot of what the anti-gun community likes to do in the court of public opinion. They're going to rely on a lot of appeals to emotion. And you're certainly going to hear as part of that a lot about, a lot of information in this case about how criminals, and maybe even terrorists use guns to kill and maim innocent lives and innocent people, all in an attempt by the anti-gunners to somehow blame the gun. But you see, in the United States Supreme Court, they cannot just exclusively argue irrationally about appeals to emotion. And why is that? It's because back in 2008, the U.S. Supreme Court relied on in-depth historical analysis to guarantee the individual right to keep and bear arms in the Heller case. That ruling in District of Columbia versus Heller established what we lawyers like to call the standard of review, or the criteria for deciding a case. Now, what the standard review means is it explains how courts go about interpreting and applying the law, in this case, interpreting and applying the meaning of the text of the Second Amendment. Because history, American history, was so central to the Heller decision in 2008, New York is desperate right now to find some historical support anywhere they can find it for justifying preventing Americans, law-abiding Americans, from carrying guns for self-defense in public. You see, besides the text of the Second Amendment, which is awfully clear to me, history also gives us meaning to what the Second Amendment should be interpreted as saying, or what it really means, right? And it does that because history reveals what the people who proposed and adopted and ratified the Second Amendment understood the terms of the Second Amendment to mean in 1791, the year the Second Amendment again was created. And bear in mind that you can really see how New York is so desperate to try to come up with some historical evidence that counters the prevailing view throughout all of American history that we are a gun culture, and of course New York has to countervail that and contradict that somehow. Let's take a look at how implausible New York's case is. You see, New York claims to have discovered old, ancient laws that restricted the right to carry firearms in public. But the two laws they appear to have come up with really did not actually prohibit law-abiding citizens from carrying arms. The first law is a 1328 statute of Northampton. That's right. I said it right. The 14th century, 1328 Statute of Northampton is how come you don't get to carry a gun, believe it or not. But what does the statute from the 14th century England have to do with our Second Amendment? Well, it's New York's lawyers, and they have very good lawyers, New York's attorneys say that this law shows that restrictions on the right to carry arms, such as guns, were accepted for many centuries. But the problem is, from the New York point of view, is that the Statute of Northampton was not a broad-based restriction on the right to carry guns in public for self-defense. Nope, that's not how it worked. You see, the Statute of Northampton basically said, and was interpreted as such, that you could not carry a gun in a manner to terrorize the people. All of the authoritative legal materials, of which I'll put some down below in the comments like I usually like to do for you, all of the authoritative legal materials from both England and from the United States confirms this. This includes leading legal thinkers like Britain's William Blackstone, there's a video on him on this channel, William Hawkins, and early American legal scholars like St. George Tucker and James Wilson. New York also claims, believe it or not, that some American colonies and states adopted Statute of Northampton analogs, or Northampton-like statutes, things that are similar to England's Statute of Northampton, and they allegedly adopted them here in the early part of the United States history. And there's some truth that that did in fact occur in several of the states. But again, the fact that these statutes were adopted here in the United States during the founding period does not mean that these statutes say what New York wants them to say, i.e. that there's some sort of a broad-based restriction on ordinary people carrying guns peaceably and lawfully in public. Let's take a look at a Virginia statute enacted in 1786. That statute prohibited someone from going out armed offensively in terror of the country. Now that's anything but a restriction on law-abiding citizens carrying guns in public. And who wrote that statute or was involved in the drafting was a prominent Virginia writer at the time named, that would be Thomas Jefferson, the author of the Declaration of Independence and one of our most important founding fathers. It's the same Thomas Jefferson who actually traveled around the early United States with a pair of pistols in his saddle. It's the same Thomas Jefferson who told his nephew, "Let your gun be the constant companion on your walks." And bear in mind that Thomas Jefferson, when it came to guns, was hardly an exception among our founding fathers. In fact, as I talk about in another video on this channel, our first 8 presidents all carried guns in public. Now, you can watch that whole video on this subject again somewhere else on this channel. I'll try to put a link in this video to help you find it if you're curious. The second law that New York's attorneys point to came out well after the founding. In 1836, Massachusetts enacted a statute dealing with the carrying of firearms in public, and other states adopted similar laws over the next few decades. Now, this doesn't really help New York and the anti-gunners in the Supreme Court, because the Supreme Court looks to interpret the Second Amendment by looking at what it was understood to mean during the founding period of our country. Now, the founding period of the United States is considered, generally speaking, the years 1760, which is leading to the run-up of the Declaration, of course, 1760, through 1826, and it's 1826, specifically July 4th, 1826, because on that date, both Thomas Jefferson and John Adams both passed away on the 50th anniversary of the Declaration of Independence. And that is considered the end of the founding period of the United States. So the fact that Massachusetts enacted this statute dealing with carrying firearms in public in 1836 is frankly too late and in the wrong time period to really be considered by the Supreme Court. Now, New York says that the so-called Massachusetts model required anyone who wanted to carry guns in public to show good cause to do so. But New York has this backwards. They just got it wrong. Okay, you see, you needed to show good cause to carry guns only if only if you were first found reasonably likely to cause harm to someone. So say, for example, you misbehaved in public with a gun without any kind of justification. Well, then you would be subject to this Massachusetts statute, but only if you had first misbehaved with a gun in public without justification. And if you were subject to the statute, even then the government could not take away your right to keep and bear arms. You could still carry. The only thing you had to do under the statute is you had to post a bond. In other words, the Massachusetts model presumed that you had a right to carry guns in the normal course. Nothing that the anti-gunners in New York are saying in the Bruen case seems to suggest any difference or any protection for what they're arguing in terms of taking away your Second Amendment rights. So as you can see, New York really does not have, in my view, strong historical support for its case. And for that reason alone, the case should be over. That's what happened in the Heller case. Once the Supreme Court found that D.C.'s handgun ban lacked any grounding in the founding era of the United States history, it struck down the ban as unconstitutional under the Second Amendment. But like I said, the well-funded anti-gun crowd has been preparing for this legal fight for many, many years. And they've used a lot of really smart intellectuals and scholars and lawyers to try to make their case. They really have worked hard on this. I give them credit for that. But the reality is history, as I see it, simply not on their side. And since I think they kind of know they can't win on the history, if you really, press them off the record, I think they would say they probably can't win on the history about American gun laws in the founding era. I think they're going to push the Supreme Court to apply a new criteria or a new standard of review that's more favorable to their side of restricting handguns in public. And I think that New York's sort of Hail Mary, if you will, if you want to call it that, is going to be to argue for some sort of what's known as tiers of scrutiny. Tiers of scrutiny. Now, this is a fancy phrase that basically gives courts an excuse to make decisions that are not based on the Constitution's text or on the Constitution's original meaning. You see, under the tiers of scrutiny doctrine, by the way, there's a video on my channel here at the Four Boxes Diner about what is tiers of scrutiny. We drill down into that for those of you interested. So under the tiers of scrutiny, the government can, in fact, violate your constitutional rights, okay, as long as it can convince a court that its governmental or public interests are so strong, so important, that they should be allowed to do it anyway. And the anti-gunners have done well with this approach in the lower courts involving the Second Amendment, because they're basically able to just say to the lower courts, hey, stopping gun violence is a problem. We need to do something about it. And a lot of the lower courts, especially in the blue states, say, yeah, we agree. Guns are a problem, and we're going to let you, violate the Second Amendment. Hopefully the Supreme Court fixes that real quick in 2022, but we'll see. Again, so in the Bruen case, you're going to hear a lot about the need to restrict constitutional rights in the name of public safety. If you read New York's brief in the case, you're going to see how it paints this picture of blood running in the streets of law-abiding citizens have the right to carry firearms in public. You see, in other videos, we'll dig into why some of these claims are fatally flawed. But for now, just remember what criminologists have known for hundreds of years. When carrying guns or carrying arms is outlawed, only the outlaws will carry guns. That's the biggest reason why gun bans do not work. And again, this concept has been around for hundreds of years. It's not a 20th or 21st century construct or invention. So let's wrap up. Here are the three things you should be on the lookout for in the Bruen case involving the Second Amendment before the United States Supreme Court. Okay? Number one, if the anti-gunners convince the Supreme Court to restrict your right to carry a firearm in public, they're going to wind up gutting your constitutional right to bear arms. Right? Because it won't be a right anymore. It will become a privilege bestowed upon those special people by government actors. And a privilege can be taken away at any time. Number two, New York's historical case, as I see it, is built on quicksand. The two historical laws they seem to point out the most really did not prevent law-abiding citizens from carrying guns for self-defense in public. And because they don't have a historical case to rely on, New York really should have no case at all and should lose big time. And number three, when you look at the anti-gun argument, you're going to see that they're going to try to distract as much as possible from the text, from the history, and from the tradition of the Second Amendment and your right to keep and bear arms, and America's longstanding gun culture, going all the way back to even before our country's founding. You're going to hear a lot of appeals to emotion by New York, and you're going to hear cries that the sky will fall if we let law-abiding Americans carry guns outside in public. But the facts and the logic are simply not on their side, and hopefully the Supreme Court will recognize this in June 2022, which is when I expect the Supreme Court to issue their opinion in Nyserpa versus Bruin. So again, thanks for joining me here today at the Four Boxes Diner, where we serve hot, fresh Second Amendment news and analysis. And if you like what you heard, please subscribe and spread the word. We'll see you next time here at the Four Boxes Diner.
Orders up. Table 2A.